and I'll be a little less glib here, that I do see, I do read and I anticipate the expansion, not just of freedom of speech, but the expansion of the word speech to be one of the primary moves that a modern Lochner court is using, shall use, will use to flex its muscles, to strengthen its power, to eliminate, to block the ability of a Colorado legislature to protect rights or to legislate for the social welfare, and not just in the context of political contributions, but now in the circumstance of cakes and websites, saying no, commerce is speech. We will say that various elements of commerce is speech, and if we can make commerce speech, then you can't block it. That could have all sorts of implications. How do you read and anticipate? Feel free to push back on that, amplify it, add texture, disagree.
I think you're absolutely right, actually, that this court has been not only very protective of speech in general, but expansive in how it understands speech. And this is not a new thing from the 303 creative case. You know, we can look at Citizens United from 2010, which obviously allows corporations to engage in political speech in a way that they had not previously. And throughout a whole suite of regulations in which it essentially has strikes down lots of different speech regulations when it comes to even things like violent video games that California was trying to regulate. So I think you're absolutely right, and this is another example of it. I mean, I think it's an open question. Yeah, I think it should be an open question whether a wedding website that someone designs is speech, and then of course whose speech is it? That's the other kind of interesting thing about this case. You go to someone's wedding website, and do you think it's the speech of the couple who's getting married, or do you think it's the speech of the person who created the website with input from the couple? The court pretty squarely said this is Lori Smith's speech. I'm not so sure that's right.
No, I mean, let's take it a step further, for good or for ill. Let's say Comcast decides it doesn't want to carry through its cables speech that says that cable should be more widely regulated. That the owner of Facebook says we don't want to allow speech, that we're not going to have speech go on our platform that says that social media should be made less addictive, or should be more transparent, or should impact kids in a different way. And there were a state or federal law that said, hey, you got to make sure you share various speech, or you got to make sure that you don't ratchet things down unduly, or you got to make sure that in fact things are transparent. And the Supreme Court says, well, wait a minute. No, what Facebook is doing is their own speech. What Comcast is doing through its cables, not just its own website, but in the infrastructure, is their own. That's the cake that they're making. And they don't want to make a cake that is contrary to their own financial interest. Set aside religion entirely, which the court seemed able somewhat to do. What's the limitation of that? Where am I getting that wrong? And or what's the best argument against the weaponization is too strong a word. I'm looking for another one, but using the First Amendment as a cudgel to block anything that democracy might do to try to make the world better.
No, I don't think you're wrong at all. And I think your hypothetical is happening in the real world when it comes to social media and political campaigns, right? That there's this push to require greater transparency with respect to the political ads that are being put on speech, with respect to AI generated content, and the social media platforms have been pushing back against any sort of regulation of this. Of course, the argument here goes to the fact that constitutional rights have never really been understood as absolute. That is to say, states have always been understood, governments have always been understood to regulate certain things for the good of the public. So, the famous old example of you can't falsely yell fire in a crowded theater. Well, that's speech, right? Someone wants to yell fire in a crowded theater. That's speech, but the court has always recognized that, look, the government has a good enough reason to limit that because of the harms that it would cause. And now you're getting to a situation where the court has basically said states don't have any rationale or any reason that they can say. And what's interesting here is that it really depends on the rights at stake that you're talking about. So when it comes to free speech, the court has said basically we're not going to trust anything or not defer to the government's judgment on these issues. But when it comes to the voting process and voting laws, the court has said we're going to defer entirely to the states in letting them enact election regulations however they want. So there's not even consistency with respect to whether we're going to trust states or not. And instead, in a lot of these things in which you see societal harms from the activity, like speech, the court has said, well, we don't really care. We're not going to let a state justify it, or as we already mentioned, the gun rights issue. But when it comes to representation, the court is saying, well, we're going to trust the politicians on that. And so, there's a real disconnect there in terms of what's going on. But, what's the best argument to push back against that is that you do have these societal harms if you don't allow this kind of regulation. It's about skewed democracy, I think is the best way to think of it. Are we going to let the few outweigh the many in the soapboxes that they have, the loudspeakers that they have, or can we allow the government to try to even the playing field a little bit? And the court has been very much against a project of ensuring some form of equality for everyone, and instead, being okay with the bigger actors in society have the outside voice.